So first, following almost 3 decades of intense work as human rights lawyer for Palestinian human rights in occupied territory, but second, also as an activist for shared Jewish and Arab life in Israel, Palestine, from my particular perspective as Mizrahi, cherishing Jewish life and history in Arab and Muslim countries, and struggling locally for equality, democracy, social justice, and peace. Dear members of the committee, I would like to start with some positive notes and then move, if I may, back to the very difficult reality in which we live day by day, especially since the 7th of October and the war. Many may not know, to start on a positive note, but until the Israeli occupation in 1967, Masafer Yatta hamlets were not all extensions of the ancient village of Yatta. Rather, it was the Israeli military occupation that restrained Palestinian development through a combination of destruction of property, expropriation of land, non-recognition of communities and villages, and zoning policies, such as the declaration of the area of Fire Zone 918 in Masafer Yatta in the early 1980s. So a little bit of quick history. The villages such as, for example, Jinba, a village which was attacked twice in the last weekend, first by settlers, wounding 7 of whom 5 were hospitalized, including minors, and second, by more than 100 soldiers and settler soldiers. The village of Jinba have in fact overgrown Yatta, turning into a vital economic and cultural center. It was the Israeli occupation and even pre-67 invasion to the then Jordanian territory that then enabled the unauthorized destruction of the southern villages of Jinba and Merkaz, cutting off the lifeline of Palestinian economy in southern Hebron Hills already before the Israeli occupation in 67. This ancient history was brought in front of the Israeli High Court of Justice, only to be dismissed and ignored. In a request I submitted as a litigating lawyer in February 2021 in the name of the local village council of Masafer Yatta to join as amicus curiae to the High Court of Justice petition against mass eviction orders from 1999 and 2000, historical evidence and artifacts were presented to the court in an effort to convince the court to look history in the eyes. And I want to share with you some of these findings. Very quickly. So you can see, this is the courtesy of Professor Michael Fischbach. So you can see Khirbet Bir al-Eid already mentioned on the 1879 Palestine Exploration Fund map. You can see also another village being attacked again and again by settlers today, the village of Gawawis. Also, you can see that, and also you can see the village of Khirbet al-Fakhit, where I have a case against the destruction of the school there. So these are ancient villages the Israeli High Court refused to recognize, even though evidence was brought in front of it. You could also see, I just want to give you an example. You see, this is a book by Yaakov Havakuk. He's a person from the Israeli Ministry of Defense. So he published a book called The Hebron Hill Cave Dwellers in 1985. And he said that, he conducted an anthropological tour in the area, and he found this, a container of grains, which was very ancient. It's called Soma. And he said, in the villages, in the hamlets where I've seen the Soma, then it was a signal of historical permanent residency in the area. So this is the book that was brought by the state to the High Court. And, when you go, and this is, for example, the Soma that was found in Jinba, okay, from the 1940s. So this picture was brought in front of the court. You can see here a cave and Hajj's from Tuba signals the place where her mother actually passed away in the cave, signaling how ancient it was. And also, again, ancient somas in Mghar al-Abid. So So what we can see is that these findings were all, a lot of work was invested and it was brought in front of the court, but the court completely dismissed it. So this is about, the history, the unrecognized history of Masafer Yatta. But the 7th of October has not only, it signaled a new era, it's signaled a new reality. Since that date, Masafer Yatta has been the target of extensive settlement activities, both in advancing outpost expansion and increasing settler violence. According to Ynet article, the military has warned against a 30% uprise in soldier violence against Palestinians. And in a court hearing, in a petition I filed against settler violence in Fire Zone 918, the state admitted that there was no indictment against any of the settlers for which complaints were filed. And I constantly hear and feel from Palestinians as well, this is not, and I feel it as a human rights activist, this is not the same military we know from before the 7th of October. Armed settlers have been incorporated formally as defense platoons into the regular military forces. They received drones, vehicles, arms, and technology, unlike before. As we know, settler violence phenomenon in the South Hebron Hills has been for years closely connected with political colonization, interest in ensuring the contiguity of Jewish settlement between the E1 area in East Jerusalem and the Beersheba northern Negev area. It was already found by Akevot organization in 1981, and I want to bring you the script for that in a government meeting. Sorry. Okay, I'm just going to read it to you because I have a problem here. So you have a government meeting in July 1981, a hearing of the Joint Settlement Committee for the Government and the Zionist Organization, a courtesy of Akevot organization. The script says as following: Ariel Sharon, Ministry of Agriculture, offers the military officers training areas. And he says, we would like to offer additional training areas. We think that additional areas should be closer to the border in the southern Hebron Hills, adjacent to the Judea desert. The phenomenon I mentioned earlier, that Arab villagers expand to the desert area, we have an interest in expanding these areas, and you can get additional training zones as well. So we have much interest in your military presence in the area. So settler interest in this area have not started in recent years. It was the very reason for the declaration of Masafer Yatta as a closed military area. Most of it was settler interest. So these settler interest upscaled, if we take a broader look at the West Bank, as the Minister of Defense Israel Katz recently declared that the construction of what they call the Fabric of Life Road, and is also known as, Naftali Bennett mentioned, known as the Sovereignty Road, is resumed in the E1 area. Such road will not only result in the suffocation of the cities of El Azariya, Abu Dis, and the Sawahra, and the Bedouin communities of Jabal al-Baba and Wadi Jimal, it also signals the end of the two-state solution. Such move must be stopped. Settler violence and settler expansion is at the point of no return, if not stopped. But I want to also connect it to something larger that is happening in Israel, especially as an Israeli citizen. Settler violence and expropriation of land in the Masafer Yatta area is highly connected to what started in January 2023 with the declaration of the judicial overhaul in Israel. So we've seen dramatic changes under this government in the structure of the military regime, turning it into a settler regime rather than a military regime. In fact, one can already speak of the end of the military regime in the occupied territory as we know it. And I will elaborate. A major change in the structure, functions, and responsibility of the Israeli civil administration took place in the aftermath of 2022 Israeli elections, whereby de jure and institutionally, the Israeli civil administration's civilian powers were divided, basically delegated to a new position, the deputy head. And he's responsible for a new administration that was established called the Settlement Administration. Okay, this Settlement Administration means that the deputy reports to the second minister within the Ministry of Defense, Bezalel Smotrich. So we have two ministers. One is the Minister of Defense and another one in another ministry within that ministry. While the second minister reports to the prime minister, primarily to the Ministry of Defense, he is motivated by explicitly by settlement expansionist and annexationist interest in Area C. This marks dramatic change in Israel's Area C policy in the nature of the military regime. The settlement administration is in fact a state within a state, incorporating the occupied West Bank into the Israeli regime de jure, in fact sustaining the de jure illegal annexation of the West Bank. The years longer functions of the Israeli civil administration have changed. We have to acknowledge that and work against that. And they're currently divided between the head of the ICA, the Israeli civil administration, and his deputy. So most of the functions of the deputy require only the consent, require only alerting and informing the military commander. Very few functions require the consent of the head of the civil administration, and only in security-related issues, the consent of the military commander. Okay, so the new division of power extend in some cases even to Area B and bypass the current lawful change of command within the military and within the Israeli regime, whereby the ICA, the Israeli Civil Administration, was subject to COGAT, the coordinator for the occupied territories, and then to the military commander reporting to the Minister of Defense. Now we have also two legal advisory offices. We have the legal advisory office for the Israeli Civil Administration and the legal advisor for the Settlement Administration, changing the very nature of legal advisory altogether. So their loyalty is highly political rather than professional, rather than to international law and to domestic public and human rights law. A petition submitted to the Israeli High Court, still pending, rejected the legality of the new structure and division of powers as undermining the very legal status of the West Bank as occupied territory, being contradictory to international humanitarian law and Israeli basic laws. Until a final Israeli High Court of Justice ruling, the new changes introduced are operational, and consequently, it's highly important to understand them and revoke them as soon as possible in any other means outside the courtroom. Just to summarize very quickly the key powers that this deputy has, this new settlement administration have, to enhance access to information. So it has enhanced access to information and control over freedom of information requests, control over planning, building, zoning, control over demolition policy, over declared state land and trespassing. You have in Masafer Yatta the situation that Palestinians do not understand. How come land that was previously recognized by the Israeli civil administration as private land, is now open for settler grazing and for settler cultivation, even olive groves. This is because of the new deputy head of the Israeli civil administration changing regulations. So all Palestinian private land, because it's not registered in land registry as most area in Area C, it is actually under survey. So areas under survey are now from this, according to this new settlement administration, is available for settlement, grazing, expansion, whatever they want to do. Okay. The other two functions is legalization of settlements, outposts, and legalization of agricultural farms, grazing zones in nature reserves and forests. So to just summarize, the 7th of October has not only seen massacres and ongoing bloodshed, it signals a new era for Palestinians and settlers living in the West Bank, and for Israelis as well. A change of the very nature of the military regime towards a de jure annexation era. The change of the very nature of the legal arena, including diminishing the functions of the legal advisory of the West Bank. A speedy change of the geography and demography of the occupied territories, involving ethnic cleansing of Area C, applying both military measures, such as what's happening in the Jenin camp, and I cannot elaborate, and civilian powers. To bring it back to this distinguished forum, to the international community, it is clear that struggling the regime change elaborated above is the main responsibility of the citizens of Israel. Many of us are doing our best in the streets, the court, public work, and grassroots work. I believe in my people's willpower to fight injustice internally for the communities that are exposed for inequality and racism, and for the victims of the 7th of October, and also externally to the Palestinian people that have been suffering unbearable degrees of ethnic cleansing, of colonization, and of apartheid. I do my utmost to make it happen, despite the very harsh conditions these days bring about. From a Mizrahi perspective, a Jewish Arab life is not only a necessity to end the conflict, it is actually an honor and a blessing to both people to live together. It means imagining normal life. Indeed, in light of the devastating condition and bleak future, we locals in Israel and Palestine feel that the judicial remedy is closing quickly, and we human rights lawyers particularly remain powerless. We call for help. It is therefore, for all these reasons, that immediate international intervention is crucial at this point, not to replace local powers, to join local powers, the brave Palestinian residents of Masafer Yatta first and foremost, and us, the Israelis that accompany them, in achieving justice for all. Thank you very much.